Regarding the issue at hand, my lord, I will ask that we play the record. We have asked the registrar to zoom in where exactly.
Listen to me. I believe what you heard, and I accept it, that this witness said he made a a written statement. Fine.
Yes, my lord.
I accept that.
Yes, my lord. Then the next question, we have not been given an explanation by the state, my lord, regarding the whereabouts of the statement that the witness has referred to.
Has written.
A written statement.
Written
yes.
statement. Fine.
Yes,
thank
because
you.
the witness, my lord, has referred to a written statement,
Right.
which has not been submitted, my lord, to the defense.
Okay, fine. I hear you.
And my lord, my submission is that it is crucial that that statement, because the witness has confirmed under oath that he did make it, that statement should be produced in order to verify, my lord, the truthfulness.
Statement should be produced by whom?
By the state, because the witness belongs to the state, my lord.
This is on the assumption that this witness has given the state the written statement.
My lord, I don't think he would have made, I agree, my lord, I don't think he would have made the statement for someone else or for any other intended purposes.
Okay, fine.
Yes, my lord, whether it was made with the investigating officer or by himself, but it should have landed to the state.
Okay, fine.
And now, my lord, we are faced with a type version on which the witness has testified with. Therefore, the defense is asking for the original statement which the witness has referred to.
Okay, fine.
And has not been submitted to the defense in order to verify truthfulness, the discrepancies, omissions, and everything, my lord.
Okay, fine.
Even the type statement, my lord, will recall that it was also produced during the trial. It was not produced.
That's not true, man. The type statement was disclosed. Hello? Mr. Baloi, wasn't it disclosed with the docket?
No, no.
Well, the statement was only taken down, I think on
the
31st
of May.
Yes.
Of July, you said?
Yeah, I think it's
because
May.
This witness was, for some reason,
31st of May, yes. 31st
Hello?
It was taken down on the 31st of May.
That's it.
Yes.
Unless you say Mr. Baloi is not telling this is called the truth. This statement, according to Mr. Baloi, was taken on the 31st of May, the typed one. Is that not so?
I think, my lord, Mr. Baloi has answered to say this statement was not disclosed to the defense before the trial started.
Fine.
It was disclosed last week.
Fine.
Yes, my lord. Which is causing prejudice on the side of the state, because what we are asking now, my lord, we're supposed to have requested it, or we're supposed to have discussed it with the state before the trial started. The original statement of the type version, my lord.
Yeah, but Mr. Baloi says there are special circumstances here. This witness was threatened with death, and he was supposed to have made the statement then, and because he was threatened with death, and I emphasize it, he was taken under the Witness Protection Program. And Mr. Baloi says the reason why, for instance, his name does not appear in the list of witnesses on the charge sheet, it was because they did not want to disclose that he was going to give evidence because he's threatened with death. And Mr. Baloi says, as a result of security reasons, this statement was only taken on the 31st of May, is it? Mr. Baloi?
Yes, it was taken down on the 31st of May.
That's the background, please.
My lord, my issue is not there regarding the fears and the protection and the safety of the witness, my lord. We understand everything. But my point is, my lord, at the time when this statement was disclosed to the defense, it ought to have been accompanied by the original statement, which the witness has referred to. But that was not done. But it appeared during trial, my lord, that the witness is still referring to that statement which he says he made.
Okay, fine.
Then my
So according to the defense, there are two statements.
There are two statements.
Fine.
Yes.
That's
yes.
basically what you're saying.
Yes, yes.
Right, fine.
And we all understand, my lord, we all have been prosecutors. We know that if there is a handwriting statement and there is a typed one, you attach both statements, my lord. We know that that's common cause. And in this case, it did not happen, my lord. And all we are asking right now, if the state is not in possession of that statement, they ought just have to tell us that, no, we don't have that statement, which the witness referred to. And
But
then we can be able to...
But Mr. Baloyi has said that. Mr. Baloyi, haven't you said that the state is not in possession of a written statement by this witness?
Indeed, my lord. That's what we said, and
that's what he says. He said it, on Friday.
My lord, I missed that when the state made the admissions, because I heard the state still referring to the notes, my lord.
Yes, the state refers to the...
I am not referring...
It's not the state that refers to the notes as I'm sitting here. It's this witness which refers to the notes. Mr. Baloyi, is the state referring to the notes?
Well, we're referring to what this witness, the explanation of the witness.
What does he say?
We're referring to the fact that the witness says all that he had were notes that he kept, and from which the statement that was read into the record was compiled.
And the state does the state have those notes?
No, as I mentioned this morning, that the information that we received this morning is that those notes...
No, but that's why this court ordered that those notes or statements, this witness must go to KZN to fetch them. Because I understood to say the state doesn't have the statement, written statement, and the state doesn't have the notes.
Indeed.
That's why this court, in interrogating whether in fact there are two statements, requested this witness to travel to Natal despite the fact that he's under threat of being murdered. And bring the notes to this court. That's why I made that order. I wouldn't have made that order. Okay, fine. Yes, Mr. Mshololo?
And then thank you, my lord, for taking that point further, because we need clarity on whether, what is it that is not available, because weight, my lord, is not the same. The witness has referred to the statement under oath. And if the statement is not available, it must be stated clearly on the record that the statement was made, it is not available to be produced to the defense. And then if, my lord, the state case is that notes were made, but then they are not available to be produced to the defense, then it's something else, my lord, because the weight that these two statements or these two documents do not have the same weight.
Evidential value.
Yes, evidential value, my lord.
Right, okay, thank you. Any other thing?
Yes, my lord. And therefore, my lord, if the statement is not available, and the submissions made by the state, my lord, especially, can I proceed to?
Aye, the whole day. I've got 2 years to hear
you. Thank you. Thank you, my lord. Especially the submissions made by the state, my lord, which refers to paragraph 3, 4, and 5. I'll summarize them, my lord. I won't refer to them as they are. Referring to the contradictions or changes that are now being made in respect of accused number 5. Had accused number 5 been privy with the original statement that was made by the witness, would have been able to look at these discrepancies on his side, my lord, referring to the statements and the type statement, my lord, and also together with the viva voce evidence of the witness.
Okay, fine, I agree. Logically, that should be so.
Yes. Okay. As a result, my lord, the defense for the accused number 5 is prejudiced by the non-disclosure of the original statement, which the witness is making correction of as being referred to in paragraph 4, 5, and 6.
And this non-disclosure is by the state.
It's by the state.
Right.
Yes.
Okay.
Yes.
Not the witness.
Yes, it knows by the state.
That's it. Fine,
yes,
fine.
Yes.
Okay, any other thing?
It's by the state, my lord. And also the further submissions made by the state, my lord, in their heads of arguments referring to Part B, privilege to Part B, and the test to be applied. It's totally different to the case that we are dealing with right now, my lord, because here we are dealing with the interest of justice, that if it is true what the witness is referring to, then the original statement ought to have been produced to the defense. It is in the interest of justice that we know as to when the statement referred to was taken and what was contained, what was the content of that original statement, which has not been disclosed. Okay. And exactly on top of that, my lord, Part B refers to the memorandums and other conversations between the police and investigating. We're not asking that. We're not demanding that. We're demanding the statement which forms part of a clip, which the defense is entitled to it. No reference to Part B and C. That is not our submissions, my lord. And also, my lord, regarding the prejudice that the defense is suffering right now, is that of having to conduct your trial or having to conduct your defense when the matter is being tried. This statement, my lord, contains...
How do you know?
Sorry, my lord?
How do you know?
No, my lord, I'm still addressing...
Yes, why, how do you know this statement?
Why I'm saying that. This statement, I'm referring to the type 1.
Oh, the type statement, not the written statement. Okay.
Yes, yes, my lord. I'm referring to the type 1. I want to address his lordship regarding the prejudice. Because...
No, you know what? You're putting the cart before the wagon, or the horses before the cart and the wagon. We are here conducting an inquiry whether there is a written statement. That's what this case is, this inquiry is about. I've given you the leeway to compare what is in this written statement and what is supposed to be in the, what is in the type statement as opposed to what should be in the written statement. You can't do that. Logically you can't do that because we only have one statement in court at the moment. Is that not so?
One submission, my
yes,
lord. Just one. My lord, my submission is that accused number 5 will suffer prejudice if he continues cross-examination without having the original statement of this statement. Yes,
you are correct. That's why this court went out of his way to make an order that this witness should go and fetch all those statements or communications or notes, because Mr. Baloyi says he does not have a written statement made by this witness. And I'm aware of the prejudice. That's why this court, in evening the playing fields, made that order. Any other judge maybe wouldn't have done that.
Thank you, Mario, and we really appreciate that.
Yes, of course.
Yes, those are my submissions.
Right. Now, I don't want to have a look. Did you bring any other thing from Natal, KZN, which is handwritten?
KZN okubhaliwe ngesandla.
Akukho, my justice.
No, nothing, my lord.
You didn't get anything?
Akukho okutholile nje.
Akukho, Nkosi.
Nothing, my lord.
Nothing. Okay, fine. Now, there is evidence, and I'm quoting my learned colleagues here, that you say you have made a written statement.
Inkantolo ithi ke kunofakazi noma kukhona ufakazi okushiwo ke abameli lapha ukuthi ubufakazi bakho kuvike endlulile
uthe sit down. Yes.
Uthe umukhuluma la inkantolo wathi kune statement owasibhala wena ngesandla sakho bathi abameli yiloko okushilo wena ngevike endlule.
My justice, into bengikhuluma ngayo mangithi kunezinto ngiyibhale ngesandla kufana nakho ngalo statement esithayipiwe ngiyabhala njengoba bengilungisa kulo ma mistake into engangikhuluma ngazo mhlawumbe ngangibhala i-date mhlawumbe ngangibhale kwi-newspaper or kwi-slip sasethilini or low notice engiyithole ukuthi kune-information
Asibambe kancane nje. What I was referring to, my lord, the witness is referring to this typed version where there are some corrections made on it. That I was referring where I would pick up that there's something, I would then correct that. Whether I was writing on a newspaper, I was writing on a receipt or a slip, but that is what I was referring to, my lord, when I said that I had wrote down. There are certain things that I wrote down. Yebo?
And my justice angaze ngenze i-statement kuyi-1 until the 31st. And that's why ukuthi my statement angisazosithatha up. Akekho noyi-1 engamenzela statement.
There's not a single person that I made a statement to except the statement that I made on the 31st. Hence then I'm surprised when he says that he's got a statement which I don't know where he or she took it from, but I've never made a statement except for the one of the 31st.
Right? Continuing this inquiry, do you know what is a statement?
Istatement uyazi ukuthi yini?
Yebo ngiyazi.
Yes, I do, my lord.
Do you know what is an affidavit?
Istatement esifungelwe i-affidavit uyazi ukuthi yini?
Yebo ngiyazi.
Yes, I do, my lord.
Now, before the 31st of May this year, were you ever called by the investigating officer or any other police official or officer to make a statement regarding this issue? To make a statement.
Ngaphambi kwe-31 ikaMeyi kuwona lo nyaka ngaba ukhona yini iphoyisa noma ke umphenyi ke umseshi wecala elake lakubiza ngaphambi kwe-31st sikaMeyi la elathatha khona ke istatement kuwena mayela nalo daba lolu?
Akekho ngangamnikeza, my justice.
I gave a statement to no one, my lord.
Did you ever swear and take an oath to a statement which you made, which oath paraphrases, I acknowledge that the contents of this statement or affidavit are true and correct, and you signed it? An oath before a police officer or a commissioner of oaths or a magistrate. Have you ever done that, sir?
Ingabe khona la khona ke owafunga khona ke lokho okubekwayo lapha ezantsi, I know and understand this, ngiyakufungela ukuthi lokho okubhalelana kuyiqiniso noma kungaphambi komanje khona la owenza statement kwafungela khona?
Akekho, my justice.
None, my lord.
As a policeman of, you said 12 years experience.
12, yes, correct.
Have you ever taken a statement from a person?
Wena ngokwakho
sikhona
statement esoke wasithatha komunye umuntu police stage?
Yebo go.
Yes, my lord.
And after taking that statement, did you administer the oath to that person to swear to the truth and veracity that he acknowledges and understands the contents of the very statement which he has or she has given to you, and that she signs it and you append your signature as a police officer?
Yes, I've done that, my lord.
So you know what a statement is.
My justice ngathi my Friday ngathi akekho ngamnikeza statement sami. I was willing ukuthi statement sami ngisenze ecourt ngoba bengazi ukuthi ozongithatha statement usisaphi futhi uzosenza.
Okay, sibambe lapho. I did say on Friday, my lord, that I gave my statement to no one because I didn't know as to the person that I was going to depose a statement to. Where is that person going to take my statement and do what with my statement?
What are those documents, sir?
They made it. This is the statement, my lord. It's the typed one. They made a copy for me.
Can you give it to Mr. Baloyi and all the defense attorneys, and then me as the last person? You've made notes on that statement.
Yeah,
fine.
Where I was correcting, my lord.
Uvutha. Yeah, the court has in its possession the type statement by Mr. Zungu, which statement was elicited through the integris of Mr. Ramusipidi. And I can see that there are markings, corrections, annotations in this document. Okay. Okay, this is the judgment regarding the inquiry into whether there is a second statement which is written as alleged by Mr. Mnisi through his client, accused number 3. It gives Mr. Mnisi instructions that there is a written statement signed by this accused. Is that accused number 3 or 2 or what? 3 or 4?
I'm representing accused number 3.
Yes, fine.